All? Right. I think, please put the heading, some fundamental rights related, some issues are in use. Let's write about them. Heading first one, personality rights. Right to personality. Personality rights of an individual. Which will be having an idea. What do you mean by personality rights? Personality rights means, see, simple. Let's say, for example, especially this applies for celebrities, but you can apply it to all. In simple terms, let's say, for example, a celebrity is there, I mean, a movie actor, actress, whatever it is, there, it can be their face, it can be their voice, or it can be their mannerisms, whatever it is. So obviously, personality rights means what cannot be done. Those things cannot be commercially exploited either by any kind of whatever advertising agencies or even the websites or artificial intelligence tools or platforms. Anybody for that matter, for commercial exploitation, you cannot use it, of course, without the permission of that particular person. That is what you call as personality rights here. I'm sure. So this is obviously, in the recent times, it has become more, it has been more in news, obviously, if you recall, because of too many artificial intelligence related apps and platforms and everything where you can directly, it's easy, right? Obviously, the face you can easily generate, voice you can easily generate. If you recall recently, I think just okay, maybe 25 end, I think, Arjit Singh, if you recall, obviously you'll be knowing that Hindi famous singer. So his voice was cloned. So it is, see, his entire identity is what? His voice. His voice itself was cloned. Then how should he make his livelihood? One is livelihood angle. Second one is what? His identity angle, his dignity angle. I mean, everything is related to that. If you clone that directly using artificial intelligence, what about their livelihoods and identities? So that's why Bombay High Court in Arjit Singh case told that. So he has the, I mean, his personality rights was protected, and they told that obviously in any artificial intelligence apps or anything, no cloning can happen without his obviously permission. Like that, obviously, I mean, there's a old case also, some 10 years old case related to Rajnikant, and then in 1990s there was a case related to some other persons like that. So many are there, but in the recent years it has become very famous. Now, obviously, the question is what? Question in the sense, what you have to remember is that why is it very, very important now? Because right to personality itself, according to Supreme Court, is part of, as we told in the morning, right to privacy. That is one angle. Two, obviously, because what is more increasing more and more now? Technology apps are increasing more and more. Obviously, you don't have to tell the so-called fake news, deep fake news, cloning, this, that. It's very, very easy to do. So obviously, in that context, it can be easily misused. Commercially, it can be easily exploited. Livelihood angle, identity angle, all those obviously will come. But what you have to understand, at present there is no specific act to deal with these issues. Some provisions under, if you recall, Copyrights Act, recall Trademarks Act, so many times you might have seen copyright issue, everything they keep failing. Under those things, there are some kind of protection. For example, they tell that people like Shah Rukh Khan, Amitabh Bachchan, what they have done, they have registered their names as a trademark. In other words, that name, all of anybody cannot use just like that. So that's a trademark, only they can use, especially in those advertisements or anything like that, it's put as a trademark one. So that is under trademark, they have registered it. Under, of course, Copyrights Act, what you can do, whatever someone has done in music or anything, just like that in artificial intelligence apps, anything, very difficult now. But what they have done, the only exception is what, if you are using, let's say someone's singing, someone's acting or mannerisms, anything, if you are using it just for, obviously, you know, right, so many what stand-up comedies are there, comedy shows are there, all of that. If you are using it for pure, what do you call it, satire or kind of caricatures, cartoon kind of a one, or maybe for sometimes academic purpose, it's allowed. But for purely which purpose, it's not allowed. Commercial purpose, it's not allowed. Assured, that is the overall idea about your personality rights. Is it needed? Of course it is needed. Why is it needed? Obviously, as I told, because of too much of increase in technology related apps, websites, artificial intelligence tools, threat of fake news, deepfake news, voice cloning, everything, it is of course needed. But what is the major limitation? Judiciary has recognized it, but what is not there? There is no particular act. So legislative loophole, or not loophole, legislative vacuum is there. Obviously they have to pass a particular act related to that. Now obviously if we are present, if any issues are there, what you have to do then? There is no act. So that's why you have to go to what? Supreme Courts or High Courts itself and then file a case. That is the only procedure that you have. Then put a case and then they'll go through it and then they'll order the websites or some apps that, okay, you take this down, you remove this, all those things they tell. Solution is there, but it's obviously approaching judiciary, everything, cost will be very high, it will take a lot of time. Obviously this era of artificial intelligence, how much ever you come up with these judgments also, obviously what's difficult? Practically it's very difficult to enforce it, because for a simple reason everybody knows, by the time you identify and then you go put the case in the courts, what would have happened? Already they would have taken it out, or any misuse that has to happen would have happened very, very quickly. That's why it's not so easy. You need the cooperation of whom? So-called, what do you call it, this social media intermediaries, or in other words, the internet intermediaries like whatever, Googles, Facebooks, plus obviously now the chat GPTs, or whatever you call them as, or any other AI tools, so many. So all their cooperation is required. Without that, practically it's impossible. Even though judiciary says anything, practically it takes lot of effort to implement. So solution is what then? First, legislature should pass a detailed act. Assured strict punishments, everything can be enforced. But of course, as we told, what should be there? The right to personality should not compromise freedom of speech and expression. That's why for artistic purpose, for academic purpose, for satire purpose, it should be allowed. Then even someone, let's say someone comes and does a mimicry, obviously no right, so many mimicries, everything will be there. What if someone calls it, that also has right, violation of my personality rights? Then what about his speech of freedom of speech and expression? That's why both also have to be balanced. Whatever, that's the broader picture. Chances of mains question, you can't expect, it depends. It depends, but keep it in mind, because continuously from last 1-2 years, it has been in use. Fine? Yeah, so please mention few points about it. Personality rights. And that first give the basic definition. It refers to right of an individual. It refers to right of an individual to prevent. Right of an individual to prevent unauthorized use of. Right of an individual to prevent unauthorized use of name. Unauthorized use of the name, voice, face, or face, distinct mannerisms and expressions. If there, remember the kind of traditional famous styles will be there, everything, distinct mannerisms and expressions. Protect all these name, voice, face, distinct mannerisms and expressions from commercial exploitation. From commercial exploitation. From commercial exploitation. So that's a basic idea. What do you mean by personality rights? And of course, what is it? It is broadly recognized under, of course, which one? It's right, right to personality. It is broadly recognized under right to personality, in other words, bracket 19, Article 21. Broadly recognized under right to personality, right to privacy, the right to privacy, Article 21. Broadly recognized under right to privacy, Article 21. Then as I told, okay, broadly what they tell, it includes two components. Includes two components, right to publicity. Right to publicity. What does that mean? Cannot be commercially exploited without without their consent. Cannot be commercially exploited without the consent of the individual, permission of the individual. Without the permission of the individual, consent of the individual. right to publicity, to right to privacy, of course, to protect the identity and privacy of the individual. Protect the identity and privacy of individual. Protect identity and privacy of individual. As we told, what is not there? At present, there is no particular legislation. Present, there is no specific particular legislation to deal with this issue. Present, there is no one particular law, particular legislation to deal with issue. No particular legislation to deal with this issue. What is it? Few provisions of Copyrights Act and Trademarks Act deal with it. That do not very detailed, just a reference. Few provisions of Copyrights Act and Trademark Act deal with it. Copyrights Act and Trademarks Act deal with it. So it is not the legislative evolution. Then who has come up with all these concepts? Yeah, that's why I mentioned below. Case laws. First one, what they tell? Rajagopal case. Right to personality was first time referred in this case. Right to personality was referred for the first time in this case. First time referred in this case. Then Puttaswamy case. It was mentioned as part of right to privacy. Mentioned as part of right to privacy. Then Arijit Singh case. His voice was protected from any kind of artificial intelligence cloning. His voice was protected from any kind of AI, artificial intelligence cloning. His voice was protected from any kind of AI cloning. Protected from any kind of AI cloning. Then, digital collectibles case. These are not landmark cases. Because the topic is in use, we are discussing it. Digital collectibles case. Digital collectibles case. Balance between right to personality and freedom of speech and expression was ensured. Balance between personality rights and freedom of speech and expression was ensured. Freedom of speech and expression was ensured. Obviously, as I told, what they told? Satire. Caricatures. Caricature means cartoons. Satires, caricatures, academic purpose or academic use does not lead to violation of personality rights. Academic use does not lead to violation of personality rights. Violation of personality. Then significance. Why is it important? Significance. Protects commercial misuse of, commercial exploitation of, protects commercial exploitation of the identity of an individual. Prevents is a better word. Prevents commercial exploitation of identity of an individual, especially celebrities. Even for individuals also it's there, especially celebrities. So two, in the era of artificial intelligence, the era of artificial intelligence, it is necessary to prevent deepfakes, voice clonings, morphings, for images, everything they morphings, etc. And obviously, what is it? Globally recognized, even in EU. Globally recognized even in EU, European Union. Even in the European Union. Sure. And obviously, what is it? Protects right to livelihood. Protects right to livelihood, identity, privacy of individuals. Right to livelihood, identity, privacy of individuals. Identity and privacy of individuals. Then practical challenges. These are not against, actually, challenges. First one, no specific legislative framework. Means there is no specific act. No specific legislative framework. No specific legislative framework. Two, that means only solution is what? Judicial intervention is the only solution. Because police can't directly arrest everything, chances are less. No, okay. Judicial intervention is the only solution. Hence, obviously, what is it? Hence, cost and delay is more. Hence, cost and delay is more. Within that, again, what happened? Or you can make another one. Different high courts have given different interpretation. Different high courts have given different interpretation. In other words, simple logic. Who has to intervene and give much better clarity? Different high courts have given different interpretation. Supreme Court has to clarify the definition, scope. Different high courts have given different interpretation. Hence, Supreme Court should clarify the definition and the scope. Clarify the definition and the scope. Clarify the definition and the scope. Then, obviously, what is it? Practically, preventing such misuse is very difficult. Practically preventing such misuse is very difficult due to anonymity in the digital domain. Rapid spread of defects. Anonymity in the digital domain and rapid spread of defects, rapid spread of defects. Then the best solution for this, obviously, is which one? First, way forward. Specific legislation has to be drafted, passed by the Parliament. Way forward, specific legislation has to be passed by Parliament. Specific legislation has to be passed by Parliament. Specific legislation has to be passed by Parliament. Has to be passed by Parliament. Line 1, 2, second one. Stringent punishments. Stringent punishments in case of misuse or violation. Stringent punishment in case of misuse or violation. In case of misuse or violation. Case of misuse or violation. Line 3, third one. Balance between personality rights and freedom of speech and expression. Balance between personality rights and freedom of speech and expression. As we have already told. Balance between personality rights and freedom of speech and expression. Then cooperation with or coordination with digital intermediaries or social media intermediaries. Cooperation with social media intermediaries. Social media intermediaries. Cooperation with social media intermediaries. This is one broader topic called as personality rights, which has been in use so many. In fact, actually, if there is Abhishek Bachchan's one case, Neil Kapoor case, so many are there, but all of them at the core is the same. This is one topic. The next topic is what? The Harish Rana one, which is, you know, to the heading, which one? Right to die with dignity. Rights to die with dignity. Again, all the angles will write. Right to die with dignity in bracket euthanasia. Right to die with dignity, euthanasia. Or mercy killing, whatever it calls. Euthanasia or mercy killing. Yeah, tell what does it mean? First, we give the broader definition. It refers to, euthanasia refers to intentional, painless, killing of an individual. Intentional, painless killing of an individual who are suffering from incurable terminal illness. Incurable terminal illness. Because what is it? Two types. First one, active euthanasia. Within that there are types, but not necessary. Active euthanasia, two types. First is active euthanasia. Obviously, what is the simple one? Injection of a lethal poisonous drug. Active euthanasia, injection of a lethal poisonous drug. Injection of a lethal drug. B. What is the second one? Passive euthanasia. Withdrawing or withholding of, taking back, withdrawing of the life support systems like ventilators, whatever, artificial feeding, voluntary one. Withdrawal of the life support systems like ventilators. Obviously, what about Indian context? In India only, passive euthanasia is allowed. In India only, passive euthanasia is allowed. Passive euthanasia is allowed. But what happens? In few countries like Belgium, Netherlands, even active euthanasia is allowed. In countries like Belgium, Netherlands, even so many are there, Luxembourg, so many they tell, but not necessary, one or two remember. Countries like Belgium, Netherlands, even active euthanasia is allowed. Even active euthanasia is allowed. Yeah, but do you have a specific act? At present, Parliament has not passed. At present, Parliament has not passed a specific act to deal with this issue. At Present Parliament has not passed specific act to deal with it. Parliament has not passed a specific act to deal with it. Has not passed a specific act to deal with it. But who has passed? States like Kerala, Karnataka has passed it. States like Karnataka, Kerala have passed it. First is actually Kerala. States like Kerala, Karnataka have passed it because they have historical cases related to that. All that is not necessary. States like Kerala, Karnataka have passed it. Fine then, of course, but what do you have? Case laws. Case laws. First one, this is not specifically related to euthanasia, but the subject, Gyan Kaur case. Even Rathinam case is also there, G-I-A-N. G-I-A-N, Gyan Kaur versus State of Punjab. G-I-A-N, Gyan Kaur versus State of Punjab. Right to die, that is Article 21, does not include, so right to life does not include right to die. It is not about right to die with dignity aspect. Right to life, that is Article 21, does not include right to die. Does not include right to die. Does not include right to die. Fine, that is Gyan Kaur case. Then of course everybody knows the landmark which one? Aruna Shanbag case. Aruna Shanbag case. Right to life includes right to die with dignity. So passive euthanasia allowed. Right to life includes right to die with dignity. Passive euthanasia allowed. Right to life includes right to die with dignity. Passive euthanasia allowed. Passive euthanasia allowed. Then common cause foundation case. Common cause foundation case. Supreme Court introduced advanced medical directives. Remember, we call it as living will. While you are alive, you can obviously write all the details. Supreme Court introduced advanced medical directives, that is living will. Living will. Passive, in the same one, passive euthanasia allowed for. Passive euthanasia allowed for patients in permanent vegetative state. Passive euthanasia allowed for patients in permanent vegetative state as well as chronically, terminally ill patients. Something which is incurable. Allowed for patients in permanent vegetative state as well as terminally ill or incurable patients. Terminally ill or incurable patients. What is it? 2023 they make the guidelines, everything is different one. 2025 or 2026 you can say, 2026 Supreme Court allowed passive euthanasia for Harish Rana, first individual in India. 2026 Supreme Court allowed passive euthanasia for Harish Rana, first individual, first case in India. That's why it is a kind of current affairs angle. Passive euthanasia for Harish Rana, first such case in India. Obviously, you know, he has been withdraw support, everything is already withdrawn. Now, normally, what is the procedure? How do they do it? Just mention procedure for passive euthanasia based on common cause foundation case. Procedure for passive euthanasia based on common cause foundation case. They gave a detailed guidelines based on common cause foundation case. Broader angle, that's just I am telling. Common cause foundation case. Obviously, what is it actually? 2 levels of medical boards are established. 2 levels, 2 stage. two levels of medical boards are established. Two levels of medical boards are established. First one, primary medical board. Primary medical board will be established by the hospital itself. Primary medical board means first level will be established by the hospital itself. Of course, what consisting of specialists, whatever, neurologists, all the, whatever they call it as, psychiatrists, all of them, consisting of specialists. Then what happens? Once they tell, yeah, maybe this person can be undergone through passive euthanasia, then what they do? Secondary medical board, established by the DC, district magistrate. Secondary medical board established by district magistrate. Established by district magistrate. Headed by district chief medical officer. Remember, they keep calling it as DMO, district medical officer. Secondary medical board established by DC or DM, headed by chief or district medical officer. Headed by the district medical officer. And of course, and specialists. Even for that, there are conditions, minimum 20 years experience, all those things. And now what they have done, in 2023, Supreme Court simplified the guidelines. 2023, Supreme Court simplified, means eased the guidelines. It is not important point, just to keep it in mind. Overall angle. Simplified the guidelines. And what they have done, opinion of the medical board should be given within 48 hours. Especially the secondary one. Opinion of medical board should be given within 48 hours. Within 48 hours. Earlier, doctors with minimum 20 years experience should be members. Earlier, means when they gave the guidelines in 2018. Earlier, doctors with minimum 20 years experience should be members. Minimum 20 years experience should be members. In 2023, it was reduced to 5-year experience. This is only procedural aspect. Even if you don't remember, it's fine. Remember primary medical board, secondary medical board. Earlier, doctors with 20 years experience should be members. Now, 5 years experience is enough. Now, 5 years experience is enough. Now comes the kind of arguments angle. Arguments in favor. Actually, this topic they can discuss it in ethics also, but they are to discuss more from ethical perspective. But here we will more broadly deal with polity angle. Arguments in favor. Why do you think passive euthanasia should be there? Arguments in favor. Obviously, why? First one, it is for whom? Exactly. It is for those patients. Is for those patients in vegetative state, that is beyond. It is for those patients who are under vegetative state, that is beyond cure, beyond normalcy. Those patients who are in vegetative state, that is beyond cure. Beyond cure. That's one. Two, as said by Supreme Court, right to life should include right to die with dignity. As said by Supreme Court, right to life should include right to die with dignity. Include right to die with dignity. Include the right to die with dignity. Sure. Yeah, then 3. What you can point, obviously, financial burden. Financial burden on the family can be reduced. Because practically imagine if for Arna Schanberg, if you recall, almost 20-23 years she was kept in the hospital. Financial burden on the family can be reduced. Financial burden on the family can be reduced. Of course, extension of that, because what can also reduce in a way? Emotional, psychological burden on the family. Emotional, psychological burden on the family can also be reduced. Also be reduced. Obviously, what is it? Chances of misuse is less, because what you have, as there are two levels of medical boards, chances of misuse is less as there are two levels of medical board. As there are two levels of medical board. As there are two levels of medical board. I like that few. Still arguments are there, and then challenges. The first major challenge is what? Lack of clear legislative framework. Lack of clear legislative framework. Lack of clear legislative framework. Actually, under arguments in favor, you can write another point above. Law Commission has also supported it. Supreme Court anyhow has supported it. Under arguments in favor, I am telling above. Law Commission has also supported it. Just add some extra point there. Law Commission has also supported it. Law Commission has also supported it. And then arguments in, challenges one legislative framework is not there. Two, second aspect, misuse by families for property disputes, commercial, commercial benefits, something. Misuse of the families for property disputes. Because as we told, chances are less because already there are two levels of property disputes. And three, which is what? Cultural angle. Culturally, religiously, cultural religious grounds. Cultural and religious grounds. Which is what? Life is considered as cultural and religious grounds. Life is considered as God's or nature's gift. Life is considered as nature's gift. Hence, state cannot take it away. State cannot take it away. Considered as a nature's or God's gift, state cannot take it away. Then next one, medical boards. Medical boards, ethical training of doctors. Medical boards, ethical training of doctors, protocols to be followed by hospitals. Protocols to be followed by hospitals. Protocols to be followed by hospitals is still not clearly established. Still not clearly established. These are the broader angles they argue for it. Of course, for that way forward, we already know same thing, reverse and right. Way forward, Parliament should pass an act on the lines of Kerala and Karnataka. Parliament should pass an act on the lines of Kerala and Karnataka. Even Law Commission suggested that they should pass it on the lines of Kerala and Karnataka. You can also add that Law Commission also recommended it. Law Commission also recommended it. Law Commission also recommended it. Then palliative care can be improved. Means elderly care. Palliative care. P-A-L-L-I-A-T-I-V. Palliative care. In bracket, if you have doubt, elderly care. Care of elders. Palliative care can be improved to take care of terminally ill elderly patients. Take care of terminally ill and elderly patients. Terminally ill and elderly patients. Then of course, who can share? State can share the financial burden. State can share the financial burden. State can share the financial burden. Yeah, and then just to mention somewhere in margin you can, okay, or else you can directly here itself you can write best interest test. Best interest test introduced by Supreme Court in Harish Rana case can be followed, should be followed. Best interest test introduced by Supreme Court in Harish Rana case should be followed. What do you mean by best interest? That is, any medical support can be continued if it is in the best interest of the patient. Means if it can be cured or brought back like that, any medical support can be continued. Best interest test. Any medical support can be continued if it is in the best interest of the patient. If it is in the best interest of the patient. Largely, this is your right to die with dignity. Two major issues: personality rights, right to die with dignity. Fine. Then third major issue, same-sex marriage, which is not present one, for the last 2-3 years continuously going on. Same-sex marriage. Same-sex marriage. Same-sex marriage. Of course, very easy. Write the basic definition first. It refers to marriages between individuals of same sex, that is men and women, I mean between men and between women, marriages between individuals of the same sex. Obviously, what is it then? That means it is opposite to the traditional heterosexual marriages between two men, between two women, that is opposite to the traditional heterosexual marriages. Opposite to the traditional heterosexual marriages. Of course, why is it in news? Simple angle. In Supreme Court in Suprio case, Supreme Court in Suprio case did not allow, Supreme Court in Suprio case did not allow same-sex marriage for homosexuals, transgenders. Did not allow same-sex marriage for transgenders. But what it also did not allow, it did not allow civil union for them. Did not allow civil union. It's like one level below marriage. Did not allow civil union for homosexuals also. Did not allow civil union for homosexuals also. What did it say? Supreme Court said that legislature should take the final decision. Supreme Court said that legislature should take the final decision. Legislature should take the final decision. Where you can't allow, Special Marriage Act does not allow such marriages. Special Marriage Act 1956 does not allow such marriages. Special Marriage Act 1956 does not allow such marriages. Does not allow such marriages. Fine? That is the context, that's why it is in news. Now obviously, is it allowed in few countries? International angle first you mention. International or internationally, globally. Globally, it is legalized in more than 30 countries. Globally, it is legalized in more than 30 countries. Even where, like US in a lot of states of US, in US, Canada, Netherlands, Australia, etc. So many are there. US, Canada, Netherlands, Australia, etc. That is the international angle. And why is it allowed? Why is it in a certain sense? It's allowed in few countries, but in the Indian angle, Supreme Court did not allow that. Now, of course, why did this question came up? First of all, because of the which one? Right to gender identity considered as a fundamental right under Article 21, transgender considered as third gender. Morning you wrote Nalsa case and everything. Because of that, now they are extending it. When you have already decriminalized homosexuality, why can't you allow next step, which is same-sex marriage? Is the argument. Yeah. Now, for that, of course, that's the question. I mean, that's the subheading. Arguments in favor of same-sex marriage. Arguments in favor of same-sex marriage. Arguments in favor of the same-sex marriage, which is very obvious. I just now told, first major argument is what? Right to gender identity is already part of Article 21. Same-sex marriage is an extension of it. Right to gender identity is already part of Article 21. Navteej Singh Johar case. Right to gender identity is already part of Article 21. Same-sex marriage is an extension of it. Same-sex marriage is an extension of it. Fine. Same-sex marriage is an extension of it. Yeah, below that, denial of same-sex marriage violates. Denial of same-sex marriage violates right to equality. 14-15. Denial of same-sex marriage violates paper-specific language. Violates right to equality. Article 14, Article 15. Means when you can allow for heterosexuals, why can't you allow for homosexuals? They can bring, I mean, arguments wise we are telling. Article 14 and 15 angle. So that is second. Then, of course, the next one is which one? Right to privacy, choice. Right to privacy, choice, and marry applies even for homosexual couples or homosexuals. Right to privacy, marry, and choice applies even for homosexual couples. Even for homosexual couples. Fine. Then next, obviously, what they'll get? Access to various benefits. Remember, you can put them as a nominee, joint bank accounts, joint property names, everything. Access to various benefits like insurance, joint bank accounts, joint property registrations, etc. Joint bank accounts, property registrations, etc. All these benefits you will get if you recognize it. Sure. And then, as we told, obviously, what it's also, child adoptions will be allowed. Child adoptions will be allowed. Child adoptions will be allowed. As obviously, what it doesn't, as the present CRA guidelines, as the present CRA, Child Adoption Resource Authority, as the present CARA guidelines, from Child Adoption and Regulation Authority, CARA guidelines, Child Adoption and Regulation Authority guidelines, does not allow adoption by homosexuals. So if you make it legal, so that option also will be there. As the present CRA guidelines does not allow adoption by homosexuals. Right? These are all various arguments in favor. Of course, and the international angle, as we have already told, so many other things you can link it to cohabitation, this, that, everything. Of course, then comes what? Challenges. What are the challenges? Major ones is obvious. First major ones. Challenges. First one, traditional, cultural, religious grounds. Challenge, complexions, whatever, complexities. Traditional, cultural, religious challenges. Obviously, which is the challenge for that? Marriage is considered only between heterosexual couples. Marriage is considered only between or allowed only between heterosexual individuals. Heterosexual couples. Heterosexual couples. To another way, this is also kind of traditional argument. Primary purpose of marriage is procreation, means next generation ones. Primary purpose of marriage is procreation. It's not possible in same-sex marriage. Primary purpose of marriage is procreation. Not possible in homosexual marriage, in same-sex marriage. Not possible in same-sex marriage. Obviously, in that context, what is the only solution then? They have to go for child adoption. That's why below that who argued NCPRC or NCPCR, National Commission for Protection of Child Rights. National Commission for Protection of Child Rights argued that NCPCR, National Commission for Protection of Child Rights, argued that child adoption by same-sex couples might have emotional, psychological impact on children. Child adoption by same-sex couples may have emotional, psychological impact on children. Is what they argued. Of course, we still don't know anything. It's all maybe the international study when they do it will have a emotional, psychological impact on the children. Emotional, psychological impact on the children. Fine. This is another kind of what you can say challenge. The traditional angles once. And then just now, as we told, clarify that Supreme Court said that right to marry is not a fundamental right for same-sex couples, homosexuals. Supreme Court argued that right to marry is not a fundamental right for homosexuals. It's not a fundamental right for homosexuals. Yeah, and then obviously what doesn't allow? Religious personal laws, like the Shariat law, like that. Religious personal laws, in bracket Shariat law. Religious personal law does not allow it. If Supreme Court allows it, then what you have to do then? That amendments have to be done. That Parliament can't do it, respective religions have to do it. Religious personal laws like Shariat law does not allow it. Does not allow it. If courts allow it, it will create legal complications. If courts allow it, even if Parliament allows it for that matter, if courts allow it, it will create legal complications. Create legal complications. Create legal complications. Considering all these things, what should be done? Way forward. Of course, whatever you have written as the loopholes, reverse it. First thing, what should be done? Legislature, Parliament should deliberate this issue first. Means discuss this issue in detail. Parliament should deliberate this issue, take a final decision. Because you can't say pass the act directly because Supreme Court also has not allowed it. Parliament should deliberate the issue and take the final decision. For that, what you have to involve? International practices should be studied. National practices should be studied to get a better idea about the impact on social stability, child's psychological health. National practices should be studied to identify, international practice should be studied to understand, whatever, to identify impact on social stability, Children's psychological health. Children's psychological health. Sure. And then obviously larger, broader one, what you can tell? Awareness. Awareness about the issue. Awareness about the issue by IEC campaigns. Information, education, communication campaigns. Awareness about the issue by IEC campaigns. Then broad-based consultation with transgender activists, broad-based consultation with transgender activists, academicians, especially legal academicians, the advocates, lawyer, professors, legal academicians, doctors, child rights activists, religious leaders, because there is a traditional cultural angle also. To get better clarity on the issue. Religious leaders, child rights activists, doctors, legal professors or whoever, to arrive or to get a better clarity on the issue. Means you can't say directly allow it, pass an act. To get a better clarity on the issue. Because Law Commission has also not said, recommended it. Supreme Court has not allowed it. Parliament has not passed an act. So we can't directly tell that it should be allowed. This is only because from the last 2-3 years it is under discussion. And then we forgot to mention morning, because anyhow Shabrimala case is under discussion related to that, the broader issue. Yeah, put that doctrine of essentiality. Doctrine of essentiality or essential religious practices. Doctrine of essentiality or essential religious practices. Essential religious practices. Essential ERP, what they call it? ERP, essential religious practices. A simple tell, what does that mean? It is a judicial innovation. It is a judicial innovation by Supreme Court in, of course, we know the landmark which one? Shirur Mutt case. Judicial innovation by Supreme Court in Shirur Mutt case. SHIRUR, Shirur Mutt case. Shirur Mutt case. And how can you define it as? It refers to the core practices of a religion. It refers to the core practices of a religion which can be allowed. Core practices of a religion which can be allowed to be practiced by the followers. Core practices of the religion which can be allowed to be practiced by the followers of the religion. Allowed to be practiced by the devotees, followers of the religion. Of course, what is it below? Supreme Court has used multiple criteria. Because there is no one way to determine it. Supreme Court has used multiple criteria. Supreme Court has used multiple criteria. Of course, like which one? First one. Is it mentioned in the holy text of the religion? Is it mentioned in the holy text of religion? Is it mentioned in the holy text of the religion? Mentioned in the holy text of the religion. Mentioned in the holy text of the religion. File 1B. Is it mentioned or was it mentioned by the mentioned or preached, whatever, described? Was it mentioned by the founder of the religion? Was it mentioned by the founder of the religion? mentioned by the founder of the religion. Mentioned by the founder of religion. 3. How long has it been in practice? 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 Then, opinion of the religious scholars. Opinion of the religious scholars. Opinion of the religious scholars. I like that multiple tests they use, and finally they'll come to a conclusion whether it should be allowed or not. Fine. Obviously below Sugarmut case is there, below that few other cases, case laws. Case laws. Case laws. Under that, I mean the first one if you want, the which one, Nikhil Soni case. Nikhil Soni case. Santara or Salekana declared as. Nikhil Soni case. Santara or Salekana declared as essential practice of Jainism. Santara or Salekana declared as essential practice of Jainism. Essential practice of Jainism. 2. Shayara Bano case. Shayara. Multiple times we have written Shayara Bano one or other way. Triple Talaq. Triple Talaq is not an essential practice of Islam, because there are two types under it. Triple Talaq is not an essential practice of Islam. It was declared unconstitutional. Shayara Bano case. Triple Talaq is not an essential practice of Islam. It was declared unconstitutional. Declared as unconstitutional. Fine. The next one. Okay, that Venkataramana Devuru case. Untouchability is not an essential practice of Hinduism. This is first major case. Venkataramana Devuru case. Untouchability is not an essential practice of Hinduism. I mean, there are few others, not necessary. This is more than enough. Again, it is in use because the review petition of Shabrimala case. Untouchability is not an essential practice of Hinduism. Not an essential practice of Hinduism. Fine. And now, why is this doctrine important? Significance. Because just commonsensically you can easily keep explaining it. Significance. Of course, first, for which purpose? Significance of the doctrine. What it does? Exactly, it brings, it allows, it brings socio-religious reforms. It brings socio-religious reforms. Socio-religious reforms. Socio-religious reforms. That is one major angle. 2. Religious practices have evolved through centuries, different value systems. Religious practices have evolved through centuries with different value system, which may not be what? Few of them may not be in tune with the constitutional values, constitutional morality. Have evolved through centuries with different value systems. Few of them, some of them may not be in tune with constitutional values. May not be in tune with constitutional values. Of course, all of them linked to one and around that. May not be in tune with constitutional values. Then, few religious practices violated rights of vulnerable sections, especially women, and you can say sometimes lower caste, as we told, untouchability angle. Few religious practices violated rights of rights of vulnerable sections, especially women and lower castes. Especially women and lower castes. And that's what is the triple talaq. If you want same, if you want example, write example, triple talaq and which one? Untouchability. Triple talaq, untouchability. All of that you can reform using it. Then next one obviously, which is it? Ideally, religious reform should be brought by. Ideally, religious reform should be brought by devotees of the religion or the religion itself, that is. Ideally, religious reform should be brought by devotees and leaders or devotees and religious leaders. Brought by the devotees and religious leaders or by the legislature. Brought by the devotees and religious leaders or by the legislature. But what happens? Due to their lack of initiatives, Supreme Court has filled the vacuum. Due to their lack of initiative, judiciary has filled the vacuum, because there is no other way. Due to their lack of initiative, judiciary has filled the vacuum. Judiciary has filled the vacuum. Of course, next related to that itself, it has helped Supreme Court. It has helped Supreme Court perform its role as guarantor of fundamental rights. Help Supreme Court to perform its role as guarantor of fundamental rights. Guarantor of fundamental rights. Guarantor of fundamental rights. Fine, that is largely the significance angle. Then comes criticisms. Of course, like our basic structure, constitutionality, all of them, some points will obviously overlap, no doubt about it. First major criticism, you tell, it has no constitutional basis. It has no this pattern by now we should have observed. In all these major doctrines like basic structure, constitutional morality, all of them, these will overlap. No constitutional basis. It has no constitutional basis. Two, obviously, whatever said and done, what you can't do? Definition, criteria, scope is not clear. In other words, easily who can use it according to their benefits? Judiciary. Definition, criteria and scope of this doctrine is still not clear. Definitions, criteria and scope of this doctrine is still not clear. Hence, subjectivity of judges is high. Subjectivity of the judges is high. So they can interpret according to their discretion. Subjectivity of the judges is high. Then 3, of course, this also same pattern. What is it? It leads to which one then? Exactly. Allows, encourages, allows over interference of judiciary into which one? Religious matters. Allows over interference of religion, over interference of judiciary into religious matters. Over interference of judiciary into the religious matters. The religious matters. So then, obviously, we have seen in so many cases that whenever courts try to implement it, who will always what kind of oppose it? Because obviously people will oppose it. That's the point. Religious reforms by apex court in Supreme Court. Religious reforms by apex court is normally opposed by the devotees. Normally opposed by the devotees, thereby affecting social stability. Opposed by the devotees, thereby affecting social order, social stability. Simple, thereby affecting social stability. Example, Which one? Yeah, Shabrimala judgment was opposed by the devotees. Opposed by the devotees. Then obviously what is it? Judges are Judges are experts in constitution and legal matters. Judges are experts in constitutional and legal matters. Experts in constitutional and legal matters. But of course, you tell, but they lack. Yeah. Experts in constitutional and legal matters, but they lack religious knowledge. They lack religious knowledge. They lack religious knowledge. And then, of course, what is allowed? Constitution itself allows freedom of religion, 25 to 28. Constitution itself allows freedom of religion, 25 to 28. Yeah, then way forward. As former CJ Chandrachud had said, former CJ Chandrachud had said, judicial restraint should be followed. Judicial restraint should be followed with respect to religious practices. Means as much as possible, try to avoid getting into those issues. Judicial restraint should be followed with respect to religious practices. With respect to religious practices. And two, better who comes up with this? Legislature should take the responsibility for any such religious reforms. Legislature should take the responsibility for any such religious reforms. Take the responsibility for such religious reforms. Only those practices which violates core values of the Constitution. Only those practices which violates core values of the Constitution should not be allowed. Rest all you allow it, just. Which violates the core values of the Constitution should not be allowed. Should not be allowed. Yeah, under criticism, you can add that another keyword also, which can be using judicio-papism, judiciary acting like the Pope of the religion. The criticism, judicio-papism, judiciary behaving like Pope of the religion. Judiciary behaving like the Pope of the religion. Behaving like the Pope of religion. This is also criticism. Broadly, I think this is more than enough. If few other issues are there, that I'll take it as obviously, as I told, over a period we'll keep doing. And that is broadly your fundamental rights. All the PYQs you have mentioned it. These are the recent major current issues related to rights. Of course, if in case again Shabrimala judgment comes, doctrine of essential practices will obviously be in news, or women rights might be in news again. Fine. So now we'll shift to another major topic, federalism. Heading federalism. First, let's list out all the PYQs. I mean, in keywords. Federalism. So you don't have to write the detailed question. just to understand how regularly they have asked the questions on it. 25. 2025, evolving pattern of center state financial relations. 2025, evolving pattern of center state financial relations. Just to have an idea, when you come back to revise the topic, you should be like, okay, all these questions were asked, it should be there at one place. Evolving pattern of center state financial relations. Then 2024, changes introduced in center state relations to improve federalism. More or less both got overlapped. Changes introduced to improve, it is in center state relations to improve federalism. To improve federalism. And that is 2024. Again, 2023, GS-2. And then first constitutional amendment 2016. How does it reflect federalism? And first amendment 2016. How does it reflect federalism? 2023. 2023, another question. 2 questions on federalism in 2023. Political legal factors that I think I showed you that, if you recall. Political legal factors that led to reduction in misuse of Article 356. The detailed answers we'll write later. First you have to identify what all areas they regularly ask questions on. Political legal factors that led to the reduction in misuse of 356, 2023. 2022, national parties favor centralization, regional parties favor opposite, state autonomy, decentralization. National parties favor centralization, regional parties favor state autonomy. Regional parties favor state autonomy. 2021, 14th Finance Commission and federalism. Because in general, for Finance Commission we'll try to mention it under your bodies. 14th Finance Commission and federalism. Then 2020, again 2 questions because of the recall COVID time. 2020, centralizing tendency of India's federalism. Because that year, if you recall, Epidemic Diseases Act was in use, Disaster Management Act was in use. Centralizing tendency of India's federalism. Centralizing tendency of India's federalism, 2020. 2020 again, cooperation, competition, confrontation of federalism. All 3 combinedly, if you recall. Cooperation, competition, confrontation of Indian federalism. How all the 3 works together or keeps going together. Cooperation, competition, confrontation of Indian federalism. 2020. So 2 questions in 2020. 19 probably there was no question. 23, 24. Yeah, 19 no question. 2018 again Finance Commission. Because that year they had appointed 15th Finance Commission, or you can mention it as 15th Finance Commission TOR. 15th Finance Commission TOR. Because what do you mean by TOR? Terms of reference. That year that created, that's a, at that time it's a current affairs angle. The theme is what? That Finance Commission is very important. 15th Finance Commission TOR, terms of reference. Then 17 also no question. 16. It's in a way union territory, but I have broadly put it as federalism. 69th Constitutional Amendment. That moment you tell 69th, 1991, which one? Delhi, conflict between CM and LG of Delhi. 69th Amendment 1991, conflict between CM and LG of Delhi. CM and LG of Delhi. Then 2016 itself, Article 370 question. Article 370, of course now they can't ask it. They have asked last year on Jammu Kashmir layer reorganization act, article 370. Again 2016 another one, 1935 act is the base of federalism. 1935 act is the base of federalism. Again that's not a theme, but as we told, historical underpinnings. 2015 cooperative federalism question. 2015 cooperative federalism. 2014 strong center question. Detailed question, we'll go through it. We'll just see now. 2014 strong center. 2013 371A special provision for Nagaland. Again that year it was in news due to some mineral resources controversy was there. 371 capital A special provisions for Nagaland. 2013 again. Article 262 interstate water disputes. Article 262 interstate water disputes. Interstate water disputes. See, that means more or less, what is it? It's a very favorite topic for UPSC, especially in which one? Mains. In prelims, they don't ask so many questions on federalism, but mains, they keep on asking it. To get 2025's question, I mean, answers will come back to it. Then, because fiscal federalism, they had not asked a single question. You go through all the PYQs there. Most of the keywords is which one? Either they ask on strong center, or either they ask on cooperative federalism, or either they ask on finance commission. These three are very specific. And Delhi also they have asked twice actually. There's another question on Delhi actually, but because there was a Supreme Court judgment, I have put it under judiciary, but you can also put it under this. So Delhi related twice they have asked, 69th amendment related CM and LG of Delhi issue, and the finance commission probably I think 3 here. Actually we have mentioned only 2 here. Fiscal federalism, I mean they link it to federalism angle. There are another 2 questions, which is a very broad question on finance commission. So that will deal with completely under your bodies, or if possible under federalism itself. So finance commission, cooperative federalism, and strong center, quasi federalism, and how it was in the last 2 years. What they ask, evolving pattern. Evolving means what? Like from the last 2-3 decades you take, or entire post independence you take, how is the evolving pattern? So that look at it, examine the evolving pattern. Even look at this, what changes government of India, union government has introduced in the domain. So that over a period they ask the evolving pattern, that they are asking in the last 2 years, but other patterns you have to keep it in mind. With the finance commission, so clarify there, just mention below theme areas, core themes, means within federalism what is a core theme. So that areas you have to focus more. Core themes, first one is what? Strong center. One or other way, strong center area you have to understand very clearly. There was quasi federalism, strong center. B, cooperative federalism. Regularly at least they have touched on that issue. Cooperative federalism. B, finance commission. 4, in the recent years, fiscal federalism. Quasi federalism, cooperative federalism, fiscal federalism, finance commission, and then as I told you, this 69th amendment. 69th amendment, Delhi. So these are within federalism, regularly repeated aspects. Other things, it depends on that particular year. This is again centralizing tendency, that's why as I told. Specifically because that year, I mean, this is not a epidemic disease act will not get repeated, because if in case you remember, I mean, but obviously in 2020 the COVID time, if in case you know that era, so what had happened, so there was an act called as Epidemic Disease Act, which actually British had passed 1897 originally, so to deal with COVID. So what Parliament did, they amended the act and gave greater powers to central government to deal with any kind of epidemics. Same way, Disaster Management Act also give greater powers for union government to handle any kind of disasters. Remember, quarantine, everything, provisions was there. All the powers was given to Government of India under Epidemic Diseases Act. So for that, and that year itself, if you recall, the Parliament passed which one? Farm bills. If in case you know, very famous farm bills that passed. I think I told you yesterday or day before. Within the 3 were there. One is the APMC Act, another one is the Contract Farming Act, and then the Essential Commodities Act. Also they amended. So all those 3. So all together it was in news. That's why they asked that famous broader question of centralizing tendency in the Indian federalism. Short. So the theme is centralizing tendency they asked. These three you forget because that is that particular year. Then as I told, broader question, cooperation, competition, confrontation, all of them together they have asked. Then this Finance Commission has told regularly, the Delhi 370 doesn't matter now because already it's been what? Abrogated. That's why last year they did not ask one question. 370 you can't ask. That's why that's the question on which one. Jammu Kashmir Reorganization Act 2019. For simple reason, because I think what 2024 end or 2025 beginning they conducted what? Elections in Jammu Kashmir. So that was based on Jammu Kashmir Reorganization Act, and if you recall which one, that Ranjana Prakash Desai Delimitation Commission was there. So based on that report, they redistributed the seats and then they conducted the election. That's the reason they asked Jammu Kashmir Reorganization Act. Even if you didn't, I mean, because hardly nobody had studied on that. Last year, nobody studied Jammu Kashmir Reorganization Act. But what you should have done, whatever are the special provisions for Delhi, more or less same, you should have just copy pasted under Jammu Kashmir Reorganization Act. 5 marks is difficult, at least 4 marks they could have got, whoever had written it like that. You know, that's why I keep telling. So just to keep it in mind broadly. In mains, you can largely divide questions into 3 categories. One is type A, another one is type B, another one is type C. So this is just I am telling you based on my experience and analysis. Everybody does it have their own one. Now what does that mean? When you say type A, it means what in simple terms? What kind of questions? Direct questions. Like for example, this year delimitation, just imagine how much was it discussed. Let's say they ask a question on delimitation. I should more or less what every serious candidate would have done. Literally point by point, word by word, serious candidates would have by-hearted it. The moment you go there, what is it? Graduation will come. Automatically, what is it? Just keep on writing. Automatically, direct question will be there. If in case they make it as direct question. Or 16th Finance Commission. I mean, continuously from the time report came, you already know by PYQs, it's a very strong theme. Again, 16th Finance Commission report is in news. They can ask it as an economy question in GS-3 or they can ask it as a polity question as a body they can ask. They can link it to federalism, anything they can ask. So obviously those kind of questions are direct. Election Commission is in news if they ask a question on that. Anti-defection law is in news if they ask a question on that. So like that if they ask, or again coalition governments are in news because of the Tamil Nadu angle. Governor question is in governor, again one or other way was in controversy. Or governors, of course last again Tamil Nadu itself, the assent to the bills and everything. So that kind of questions if they ask, those are all what? Direct. Automatically what happens, number of points will be more, and here your chances of getting how much? 50% is very, very high. So 5 out of 10, 7.5 out of 20 is high chances because points are there. You just stick to which format here, that's what I told. The moment you understood, you identified it's a type question, I mean you have to follow which point approach, I mean typical point format approach you should stick. Type B means what then? You know what is the topic, but what is it? It's not a very direct question, it is a broad, vague question. Because it's a broad and vague question, obviously what is less? Specific content is less. Means you know what is the demand of the question, but you are not able to generate so many points because it's very, very broad and vague. As I told you yesterday, for such kind of question you should follow what kind of format? Short para format. Short. And always remember, type A questions will be telling you maximum, you can say 13 to 15 will be your type A. Short. It can go less actually, considering the way they are making it as and when competitive, it can become 10 also. Short. If they want to make it like your prelims, they can make it as 7 also. So only 7, 8 questions will be direct, rest all they will make it as what? Type B. So such a broad question they will ask that you know what is the demand, but what is not there. At that moment, how do you generate specific content? So that's a challenge, that's the game that obviously UPSC plays. And deliberately what they will do, where you have specific content, they will make it as 10 marker. You have so many points to write, but they will ask it as what? 10 marker. So now what is the challenge actually? That's also a challenge. If you have more content and you have less space, The challenge is what? How do you manage space? Which one will you write? Which one will you leave out? That's actually a challenge. And what deliberately UPSC will do? Type B question, they'll ask it as 15 marker. Space management challenge again. How much will you beat around the bush? How will you manage the space? That's actually a management challenge. Such kind of question, again I am telling you, aggregate ways. It can again, as I told, if you want to make it easy for you, type A can become 15, 16 also. If they want to make it difficult for you, it can become 10, it can become 8 also. This is average. 12, 13, 14 is the average. This is normally 4 to 6, again depending on which one. If type A questions are more, this is less. They are less, this is more, 4 to 6. Assured. Then comes your type C, which is what? Which is random question. Random question means they'll ask question on sometimes some topics where absolutely have not even heard single point about it. So like normally in GS-2 and GS-3 such kind of questions are less. In GS-1 they'll ask it under geography, or sometimes in GS-3 they'll ask it under science and tech, where all of a sudden they'll ask a question wherein you don't even know, actually you have not even heard about it. So for example, in in IR they had asked some almost 10 years back, they had asked a question, UNESCO McBride Commission report they asked. Nobody knew what is McBride, like how they ask it in your prelims. Sir, what is this? I don't know any idea. McBride Commission was appointed, I think somewhere in 70s or 80s. There was no news, no current affairs angle, nothing. They just asked, write a detailed note or something like that, very broad question. McBride Commission. What do you know about McBride? Most of us, even when because even I wrote at that, so what we did? You don't know McBride, what you have to write? About UNESCO, how much ever you know, you have to write that. So of course it's not direct valid, but there's no other way. So what they would have done, maybe they would have given you 1 mark, 1.5 mark, whatever, how much ever, whatever is they give you, it's just additional one, you just have to take it. But that kind of questions in GS2 are normally rare. But I am again cautioning, because the way prelims has happened, anything can happen, who knows. What if you have 3 random questions, 4 random questions? Can't help. Sure, you have to be ready, especially those writing this means I am telling. We'll see, based on this year's, at least you may have an idea for next year, but whatever. That kind of questions, as I told, normally is 0. Maximum is 2. It's also rare, actually 1. Sure. And in the last almost 5-6 years, 0 random question in GS2. GS1 they tell they ask, GS3 they tell they ask, GS2 normally such kind of questions are not there. Sir, what if such kind of questions are asked? Obviously, as I told, you keep it at the end, and what do you have to do? If you don't know the exact demand or anything, same process, what do you have to tell? What are they broadly asking about? Identify the topic, whatever you know in and around the topic, you have to manage it. Don't take it, don't write it in the beginning or at the end, or the mid. Always what? That's some last 5 or 10 minutes, whatever is left out. So whatever you know about that particular topic in and around, just fill the space for maybe one side, half a side, how much ever, 1.5 side. At least you will get how much? 1.5 to 2 marks if it is 5 marker, maybe sometimes 2.5, 3 marks in a 15 marker. You never know, your cadre might change because of that. Anything can happen, right? It's a matter of 1 mark. Your service itself might change. You can just get into the list because of that 1 mark. So anything can happen. So don't leave out and come back. There is no way of leaving, sir, I left 2 questions, rest all 18 questions I have done very well. Doesn't work. Because as we keep telling multiple times I have told, in one question, you will not get a huge advantage. 3, always keep it in mind, evaluator will be very, very, what you can say, lenient towards you till 30-40% score. Means out of 10 marker, he'll easily give you 3 to 4. But he'll be very, very, harsh in giving you that. The rest 0.5, 1 mark, he'll be very, very harsh. So 3 to 4 is very easy to score in prelim, in 10 marker. Or 4 to 5 is very easy to score in 15 marker. You just write something around the topic. Sir, I have not given any substantiation. Absolutely fine. They'll give you 3.54 easily. But core demand you have to address. So that's why first 30-40 score is easy, percent score. The last 10% score or 15% score, that is 0.5, 1 mark in every question, that's where always the game is. So whatever you are doing, all of that, even like whoever is rating means this time, whatever they have major sources, even if they go read that, go and write the paper and come and complete the paper and come back, even now without any notes also, you can easily get in 90s. 95, 100 you will easily get. You have to complete the paper, write decent, address the demand of this question decently, have basic decent presentation. 95, 100 is easy. GS-2 I am telling. But what is it not, as I told? It's not useful, so because it will not help you in any which way. Every average candidate will get in 90s. The question is all about which one? 1 mark per question. For that, imagine how much of effort are you putting just for 1 mark for one question. So that overall paper will be how much? 20 marks in a paper. That's the game that you are playing for. Fine. Yeah, so this is always keep it in mind, especially anybody, especially those who are whoever is going to give mains this time. The moment you look at the question, ask yourself, is it my A category, B category or C category? A means tell yourself, okay, I have more chances to score, point format, let me finish as early as possible, because anyhow it's in a flow. B category, chances of filling the space is also challenging. So type A format, fill the entire space, 2 sides, 3 sides. Type B question, write how much? 1/3, 2/3, more than enough, because you would have already managed so much. Even you know, even evaluator knows that you have managed it. Assured, but still they will give you 30 to 40% score. Assured. And then random question, you keep it at the end. How much ever you know, in and around whatever keyword that you find in the topic, because you are not even knowing what is the demand. Whatever keyword is there, write about it, how much ever you want it at the end, only for that one, maybe maximum 2 marks. Is that clear? Yeah, just some who, if you didn't know, please note down, because this is what will give you clarity while you write the 3-hour exam. Put it down so that you have a clarity about it. You go and analyze the PYQs, you can sit and do. Plus 2025 you take, 2024 you take, you will get an idea what I am trying to say. Then first what we will do, we have to write the basic content with respect to federalism. Then we will write PYQs. Then we will come back to the any major issues that are in news. Okay, so just take a 5-minute break. I think a lot of them are, I think you guys want a break. 5 minutes, go back and come quickly, and then we'll do the content part for federalism. Please note down whatever the content part that is required for federalism 1. See, if you recall, actually even in normal foundation class also we deal very in detail. So those points, types of federalism, everything, because regularly they keep asking on cooperative federalism, everything, same definition, same examples, you can always use it. Right, few basic ones. First, write the basic definition. It refers to division of powers between minimum two levels of government. Division of powers between minimum two levels of government in the written constitution itself. Between two levels of the government in the constitution itself. The constitution itself. Right? Of course, you know, just basic, very quick features of federalism. Just the keywords. Write as a list, you write it as a list, that's your comfort. Features, very quick keywords, even in prelims you study that. In mains, exact keywords, you sometimes it might help. Of course, they'll not ask you direct question like what are the features of federalism. We are telling you, writing this only because those keywords should be there in your mind. First is dual polity, not dual government, dual polity, to division of powers. Dual polity, the division of powers, second one. Third, written constitution, dual polity, division of powers, written constitution, supremacy of constitution, rigidity of constitution, independent judiciary, bicameralism at national level. Bicameralism at national level. Bicameralism at national level. US is world's oldest successful federalism. US is world's oldest successful federalism. World's oldest successful federalism, famously described as indestructible union of indestructible states. Famously described as, these are all of course basics, this you would have studied. Indestructible union of indestructible states. Then India follows Canadian model of federalism. India follows Canadian model of federalism. Same, you know that, famously described as indestructible union of destructible states. Very simple basics, these are all. Famously described as indestructible union of destructible states. Indestructible union of destructible states. Fine. Yeah, then write those, because those descriptions, because as we keep telling, anytime you can use them. Just put a small subheading. Description of India's federalism. Descriptions of Indian federalism. Description of India's federalism. First one, KC Ware, quasi-federalism. So whenever there is a question on strong center, you can tell as described by KC Ware. KC Ware, quasi-federalism. Granville Austin, cooperative federalism. Granville Austin, cooperative federalism. Granville Austin, cooperative federalism. Sir Ivor Jennings, federation with strong centralizing tendency. Sir Ivor Jennings, federation with strong centralizing tendency. See, whenever there is strong federalism, strong central question, if you want, you can also mention as described by Sir Ivor Jennings. Then Maurice Jones, bargaining federalism. In the fiscal federalism angle, you can mention this. Maurice Jones, bargaining federalism. Bargaining federalism. Paul Appleby, extremely federal. Paul Appleby, extremely federal. Justice Beg, amphibian federalism. Justice Beg, amphibian federalism. Justice Beg, B-E-I-G, amphibian federalism. Amphibian federalism. Then S.R. Bommai case, federalism is basic structure. S.R. Bommai case, federalism is basic structure. In this federalism topic, we'll combine your to an extent center state, interstate, all of them together will combine. These are descriptions. Now continue below. Strong center, quasi-federalism. Strong center. Yeah, because if you recall, that's a very famous theme. Strong center. Under that, because there is also, if you recall, they have asked a question, why national parties favor centralization? Even for that, in a way, these are the reasons, but few other reasons are also there. Strong center, under that, it's a small topic. Reasons for India choosing strong center. Reasons for India choosing, adopting a strong center. Reasons for India adopting strong center. Very quick keywords. First major reason is what? Exactly. First one, need to ensure unity, integrity of the country. Necessity to ensure unity, integrity of the country. So without strong center, it's not so easy to establish it. Necessity to ensure unity, integrity of the country. Fine. 1. 2. Scarcity of resources. Scarcity of resources. Hence, Government of India, GOI, scarcity of resources, hence Government of India followed centralized planning-based development model. Government of India followed centralized plan-based, 5-year plan-based, centralized plan-based development model. Centralized plan-based development model. Top-down approach. What in bracket, if you want, you can also mention it as top-down approach. Top-down means center will decide everything, they'll give the details, everything, you just have to implement it. Top-down approach. 3. Uniformity in policies and programs across the country. Uniformity in policies and programs across the country. This is in a way an answer for your why national parties favor centralization. Uniformity in policies and programs across the country to address regional imbalances and promote inclusive growth. Uniformity in policies, programs across the country to address regional imbalance, promote inclusive growth. Address regional imbalance, promote inclusive growth. Address regional imbalance, promote inclusive growth. Fine. The next one, absence of strong regional parties and leaders. Absence of strong parties and leaders. Absence of strong parties and leaders. Bracket, Congress system era. Everywhere it was Congress, national, central level, state level, Congress system era. Then if you want other one, historically, India always followed strong center. Historically, India always followed strong center, even during British era. Historically, India always followed strong center, even during British era. Always followed strong center, even during British era. India always followed strong center, even during British era. Yeah, these are the reasons. Then, features of strong center. Features in the sense, what are the provisions that support strong centers? Very quick, just the keywords. Details, everything you will be knowing. Features. First one, greater legislative powers to center. Greater legislative powers to center. Simple. Example, union list, concurrent list. Greater legislative powers to center. Example, union list, concurrent list. And even where does it dominate? Even in residuary list. Or you can mention union list, concurrent list, residuary list. You can write even in residuary list, parliament dominates. Union list, concurrent list, residuary list. 2. Greater financial powers to center. That's what is your fiscal federalism topic. Greater financial powers to center. Greater financial powers to center. In 1950s, vertical devolution was less than 10%. I think somewhere around 7 to 8. In 1950s, vertical devolution was less than 10%. Less than 10%. Point 3. Single constitution, single citizenship. Single constitution, single citizenship. Single constitution, single citizenship. 3. Amendment by parliament, constitutional amendment by parliament. Only parliament can amend it. That anyhow we have already discussed, no need to go back. Constitutional amendment only by parliament. Only by parliament. 3. Next point, emergencies, emergency provisions. Emergency provisions. Then office of governor. That again, governor will discuss in detail, agent of center, all of that reasons will do it. Office of governor. Then integrated election audit machinery. Integrated election audit machinery. Integrated election audit machinery. All India services. Integrated judiciary also in a way. Finance Commission also in a way, so many are there. All India services. This is quasi-federalism. Of course, then if you add cooperative, competitive, that is how it has changed over a period of time. Then these two, especially asymmetric, they are still not, if you have, by now we have already written all the mains, federalism related mains question. So which all keywords you found? Strong center. That means in other words, which one? Whatever you wrote now, quasi-federalism. That's at least 2-3 times they have mentioned about it. Then which one? Cooperative, at least 2 times they have mentioned. Competitive confrontation, in one question they have mentioned. Fiscal federalism, last year they mentioned. But asymmetric is another very, very important federalism, which they have still not mentioned. It means which they have still not asked a question on it. Anytime you can expect that. Ashok, that's your next topic. Symmetric federalism first. Symmetric federalism. Symmetric federalism. Symmetric federalism. Equal treatment. Equal treatment for all the regional units, the states. Equal treatment for all the regional units. Equal treatment for all the regional units. In other words, what is it? Okay, clarify that. Borrowed from or successfully followed in, whatever. Successfully followed in US. India follows it with respect to India follows it with respect to big states. As we told, general category states. General category, special category. India follows it with respect to big states. Simple example: legislative, executive, financial powers of. Example: legislative, executive, financial powers of most of the states are the same. Bracket except special category states. Legislative, executive, financial powers of most of the states are the same. Bracket except special category states. Except special category states. That's what is our main topic now. Asymmetric federalism. This can be, so continuously we were telling from almost 3-4 years, I was regularly telling fiscal federalism. They have not asked a question. Anytime they can ask. Last year they asked that question. So again, now again we are telling asymmetric. They have still not asked. Anytime you can ask they can ask a question on it. Let's just write a basic definition now. Asymmetric federalism. Different provisions for different regional units. Special provisions also you can say. Different provisions for different regional units, considering their different provisions for different regional units, considering their unique history, culture, considering their unique history, culture, development parameters. Strengths and weakness. Unique history, culture and development parameters. Of course, what is it? India is the most successful model. India is most successful model. India is the most successful model. Yeah. What are those examples, features or examples, whatever? Features. Article 371. 370 also we can write, but it's already abrogated. 371. Special provisions for northeast states. Special provisions for northeast states and few other states. Of course, you know that entire one. Special provisions for northeast states and few other states. You know the entire list, that factual aspects, that doesn't matter much for prelims, I mean for mains. Then 5th schedule, 6th schedule areas, provisions. 5th schedule, 6th schedule provisions for tribal areas. 5th schedule, 6th schedule provisions for tribal areas. 6th schedule provisions for tribal areas. There is, if you want, ILP, inner line permit provisions. ILP provisions. Inner line permit provisions. Inner line permit provisions. Fine. The next one. Special category states. Special category states. Special category states. Mention what are they? Northeast states plus Uttarakhand plus Himachal plus Telangana. Northeast states, Himachal, Uttarakhand plus Telangana. In case you have forgotten, just mention there, introduced by Finance Commission. Introduced by Finance Commission. Just few points. Introduced by Finance Commission. Mention that below. Criteria. On what basis was it given? Criteria. You recall what are the criteria? First one, tough geographical terrain. Difficult geographical terrain. Tough geographical terrain. B, sharing international borders. Sharing international borders. C, infrastructural backwardness. Infrastructural backwardness. 4. Low state GDP. Low state GDP. 5. High ST population. High ST population. Now, why was it given? Advantages. Advantages. More grants will be, more central grants will be given. More central grants will be given. More central grants will be given. To greater share in externally funded projects. More central grants will be given. Second one, greater share in externally funded projects. Greater share in externally funded projects. Externally funded projects. 3. Tax incentives or tax discounts. Tax discounts for companies in these states. Tax discounts for companies in these states. For companies in these states. Yeah, but as we told, what has happened? Clarify below. Post 15th, post even 14th actually, post 14th, 15th Finance Commission, this is outdated. Post 14th and 15th Finance Commission, this is outdated. Means they don't even use this factor. It is outdated. Okay, just to broadly keep it in special category status. The next example under asymmetry, as we told, differences between states and UTs. Different provisions for 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 states and UTs. So within that, what happens? Within that below, UTs like, few UTs like Delhi, Puducherry have their own legislature. Few UTs like Delhi, Puducherry, JK have their own legislature. All this is asymmetry. Have their own legislature. Have their own legislature. Now, significance of asymmetric federalism. Do you think this model is good? It works like that. Significance of asymmetric federalism. First point is what? Suits India's cultural, historical diversity. Suits India's cultural, historical diversity. Suits India's cultural, historical diversity. Historical diversity. Sure. Example, obviously which one? Example 371, 5th schedule, 6th schedule. Cultural, historical diversity. 371, 5th schedule, 6th schedule. Yeah, the next one. Recognizes distinct identities. Recognizes distinct identities, thereby enhancing unity and integrity. Thereby enhancing unity and integrity. Enhancing unity and integrity. Best example is an example. Special provisions for Northeast states integrated them into India. Special provisions for Northeast states integrated them into India. Special provisions for Northeast states integrated them into India. Integrated them into India. Then protects vulnerable sections. and their identity. Protects vulnerable sections and their identity. Was the best example. Protects vulnerable sections and their identity. Example, tribal areas are administered based on their own community laws, customary laws. Tribal areas are administered based on their own customary laws. Administered based on their own customary laws. Based on their own customary laws. Their own customary laws. Then development of backward areas to address regional imbalance. We just have to logically generate the point. That's it. Development of backward areas to address regional imbalance. Simple example. Example 371J. Special provisions for Hyderabad, Karnataka region. 371J or special category states for that matter. Special provisions for Hyderabad, Karnataka region. Hyderabad, Karnataka region. Fine. Then obviously what is it? Based on the values of equity. Based on the values of equity. Based on the values of equity. That is treatment based on strengths and weakness. Based on the value of equity, treatment based on strengths and weakness. Strengths and weakness. These are all obviously advantages or significance. Of course, what you have challenges. Challenges, or you can say criticisms. Challenges or criticisms of this model, asymmetric model. Of course, again logical challenges or criticism. First one, politicization. Politicization of the provisions. Politicization of provisions. Simple. For example, backward states like Bihar, Jharkhand were not given special category status. Backward states like Bihar, Jharkhand were not given special category status because they demanded a lot. States like Bihar and Jharkhand were not given special category status. So they use it according to the political party benefit, politicization. Were not given special category status. So that's a politicization is a huge criticism. Yeah, second major criticism. Second is obviously which one? Obstacle to unity and integrity. Obstacle to unity and integrity of the nation. Obstacle to unity and integrity of the nation. A famous criticism was with respect to which one? Article 370 was criticized. Article 370 was criticized. Article 370 was criticized for providing special status for J&K. 370 was criticized for providing special status for J&K. 370 was criticized for providing special status for Jammu and Kashmir. Yeah, then 3, reverse it. What is it? What does it do actually? Affects development. Affects development as property rights will be restricted. As property rights will be restricted. Property rights will be restricted. Simple, even today, for example, even today, very less industries are established in northeast states. Even today, very few industries are established in northeast states because, of course, there will be so many other angles. Geographical reasons will be there, historical reasons will be there. One of with this aspect. because property rights are difficult. You can't buy property so easily. Lands are not so easy. Even today, very few industries are established or functioning in Northeast. That's another criticism. And then next one, what you can say, the angle, tribes angle, politicization. Okay. You can say these states are forced to depend on. They are forced to depend on center for additional financial help, because everything they'll only be giving. They are forced to depend on center for additional financial help. Forced to depend on the center for additional financial help, especially which one? Example, special category states. Special category states. Yeah, aid dependency, what they call it as. If you want in bracket, you call it, they mention it as aid dependency syndrome. Aid dependency syndrome. So you'll be forced to depend continuously. Aid dependency syndrome. Yeah, but as we told, what you have to tell, despite criticisms, asymmetric federalism is, despite criticisms, asymmetric federalism is more accommodative of India's diversity. Asymmetric federalism is more accommodative of India's diversity. More accommodative of India's diversity. More accommodative of India's diversity. So, hence what we should do? It has to be continued. It has to be continued by addressing the challenges of politicization. It has to be continued by addressing challenges of politicization and clearly defining the criteria. Clearly defining the criteria and the scope. Clearly define means whenever they want to provide additional financial help or anything, clearly defining the criteria and the scope. This year, if in case you can expect this question, because they have not even touched asymmetric federalism till now. Again, not very highly in use. Only thing is it is left out. It is because the rest all they have already asked questions. Cooperative they have asked, fiscal they have asked, strong center they have asked. It is the only one which is left out. Of course, you can go search, add some extra points, add some extra criticisms also. You can do that. You can 1 or 2 extra points you will get. Do the value addition thing also. And then 3 things together, providing cooperative or you can also call it what, collaborative or accommodative federalism. Even if you use any words, no need to get confused, all of them mean the same. Cooperative or collaborative or accommodative federalism. Yeah, right, that famous statement, based on the principle of strong states make strong nation. Based on the principle of strong states make strong nation. Strong states make strong nation. Based on principle of strong states make strong nation. Punchi Commission described it as dharma of center-state relations. Punchi Commission described it as dharma of center-state relations. Then first write the basic definition. It refers to healthy cooperation between center and states as well as between the states. Healthy cooperation between center and states as well as between the states. healthy cooperation between center and states as well as between the states to realize the goals of constitution. Realize the goals of constitution. To realize the goals of constitution. That's the basic definition. Now under that, vertical cooperative federalism, that is between center and states. Vertical cooperative federalism. Vertical cooperative federalism. Just quickly mention some 3-4 examples. Example. First one, you can say Niti Ayog. Niti Ayog is replacing, of course, Planning Commission with Niti Ayog. 2, GS-2 Council. The moment you write GS-2 Council in bracket, you write 279 capital A. GS-2 Council, 279 capital A. Then Interstate Council, the moment you write that, you should mention 263. Interstate Council, 263. Interstate Council, 263. Then, of course, again, in fiscal federalism also, increase in vertical devolution. In bracket, post 14th Commission, it is 42, then 41, 41. Increase in vertical devolution, bracket, post 14th FC. Post 14th Finance Commission. See, based on this only, they have asked you this year's and last 25 and 24 question. You'll answer. Once we write fiscal federalism, it will be easy to write. Then horizontal. Horizontal cooperative federalism between the states. Horizontal cooperative federalism between the states. Between the states. Of course, famous examples are there. Between the states. Example, zonal councils. Bracket, States Reorganization Act 1956. Zonal councils, States Reorganization Act, SRC. States Reorganization Act 1956. Then Ek Bharat, Shresth Bharat initiative. Ek Bharat, Shresth Bharat initiative. Ek Bharat, Shresth Bharat initiative. Then sharing of best practices. Sharing of best practices. Simple. Within that example, if you want, MDMS started in Tamil Nadu, implemented across the country. The famous example, but there are so many are there actually. MDMS, midday meal scheme, started in Tamil Nadu, implemented across the country. Started in Tamil Nadu, implemented across the country. For that, obviously, cooperative federalism challenges are quasi-federalism, confrontation, everything. That is one major cooperative federalism. And then two, which one? Competitive federalism. That's what is your one of the famous question. Competitive federalism. First, write the basic definition. Healthy cooperation between. Healthy competition between. Healthy competition between center and states as well as between the states. Healthy competition between center and states as well as between the states. As well as between the states. So obviously what is it? It is a post 1990s phenomena. It is post 1990s phenomena. Post 1990s phenomena. Same below. Then vertical competitive federalism. Center and states, how they keep on trying to perform better of each other. Vertical competitive federalism between center and states. Simple. Mention both Government of India and states. Both Government of India and states compete to bring, both center and states, the Government of India and states compete to bring reforms in ease of doing business, investments, labor, land related codes or laws. Investment is of doing business, labor and land related laws. Overall it's about largely private sector angle, labor and land related laws. Of course, both of them, you can also say both of them compete to implement policies and programs. So they will also implement education policy, you will also implement, they'll also implement health programs, you will also implement. Both of them compete to implement policies and programs. If you want related to education, health, agriculture, overall welfare, compete to implement policies, programs related to education, health, agriculture, etc. That is healthy, positive, vertical one, vertical competitive federalism. Then same pattern, horizontal competitive federalism between the states. Horizontal competitive federalism, that is between the states. Between the states. Simple ones, example. Well, investment summits like Vibrant Gujarat Summit. Investment summits like Vibrant Gujarat Summit. Global Investors Meet, Karnataka. Vibrant Gujarat Summit, Global Investors Meet, Karnataka. GIM they call it as. So many are there, that's fine. That is one. Global Investors Meet, Karnataka. That is one. Two. Second major ones. Rankings by Government of India. Rankings, indices. Rankings by Government of India like. Rankings by Government of India like, of course, you know, 2 or 3 you mentioned. Yeah, Swachh Bharat rankings, Good Governance Index, SDG Index, etc. Swachh Bharat Index, Swachh Bharat rankings, Good Governance Index, SDG Index, etc. SDG Index, etc. SDG Index, etc. Yeah, like that. That is your horizontal competition. That is between the states to attract more and more investments, jobs, reforms, everything. Then confrontational federalism. Confrontational federalism. Or you can also write in bracket combative. Confrontational or combative federalism. Combative is more extreme form. Which negatively. Political, ideological confrontations between. Political, ideological confrontations between. Political, ideological confrontations between center and states as well as between the states. Political, ideological confrontations between center and states as well as between the states. Obviously, what is it? This affects cooperative federalism, unity, integrity of the country as well as development priorities. Affects cooperative federalism, unity and integrity of the country as well as development priorities. Obviously, what did it evolve? It evolved with the rise of regional parties. Started with the rise of regional parties. Evolved with the rise of regional parties. Evolved with the rise of regional parties. With the rise of regional parties. Fine, then under that, vertical confrontation. Vertical confrontation between center and states. Vertical confrontations. It was very simple. First one, misuse of office of governor. Misuse of office of governor, 356. Misuse of office of governor, article 356. Office of governor and 356. Point 2, Tamil Nadu opposing NEET NEP. Tamil Nadu opposing NEET and NEP. West Bengal opposing CBI. West Bengal opposing CBI. Then Kerala opposing UCC CAA. Kerala opposing UCC CAA. Still so many are there, fine. Means notes aspect, it's fine. Then horizontal confrontation. Horizontal confrontation. Horizontal confrontation. You know that, right? Interstate water disputes. Interstate border disputes. If you want, you write that. Interstate water disputes. Interstate water disputes like Krishna, Kaveri, Narmada, etc. Interstate border disputes. Interstate border disputes. Interstate border disputes. Fine, that's your confrontational federalism, how it has kept on affecting India's unity, integrity, all of that you have written. And then that very famous now, in a way they have asked you a 2025 question, fiscal federalism. Fiscal federalism. Fiscal federalism. Financial relations between. Financial relationship between center and states as well as between the states. Financial relationship between center and states as well as between the states. Between center and states as well as between the states. Famously described as lifeblood of center-state relations. Famously described as lifeblood of center-state relations. Lifeblood of federalism. Famously described as the lifeblood of federalism, center-state relations. Obviously, what is the parameter? Continue there below. In the post-independence era, greater financial powers has always been with whom? Center. In the post-independence era, greater financial powers have always been with the center. Financial powers have always been with the center. We told especially during plan-based development era, 5-year plan-based development era. Especially during 5-year plans-based development era. Five-year plan-based development era. Yeah, obviously, as I told, first major issues are there, which one clarify that historically what is that itself will become means answer that we'll write later. Clarify that below. In 1950s, overall we'll trace it from then till now. 1950s, vertical devolution was less than 10%. 1950s, vertical devolution was less than 10%. Vertical devolution was less than 10%. Then, discretionary grants, Article 282 was greater than statutory grants, Article 275. Discretionary grants was Article 282 was greater than statutory grants, Article 275. Discretionary grants was greater than statutory grants, 275. Greater than statutory grants, 275. Then Planning Commission dominated Finance Commission. Planning Commission dominated Finance Commission. Planning Commission dominated Finance Commission. Sorry, Planning Commission, yeah, Planning Commission dominated Finance Commission. Then uniform policies and programs. Uniform policies and programs were followed. Bracket, one size fits all approach. Uniform policies and programs were followed. Technically called as one size fits all approach. One size fits all approach till 1990s. Till 1990s. Of course, with that what happened? Hence, greater resources were with center and states acted as implementing agencies. One size fits all approach. Center or greater resource allocation of greater resources were with center. Greater resources were with center. States acted as what? Implementing agency. So whatever they tell, you should just follow. States acted as implementing agencies. States acted as implementing agencies. Fine. States acted as implementing agencies. Then centrally sponsored schemes dominated. Very huge. Centrally sponsored schemes dominated with huge. Centrally sponsored schemes dominated with huge share of conditional, that is tied grants. With huge greater share of tied grants. Bracket conditional grants. We call all those basics. Centrally sponsored schemes dominated with greater share of tied grants, that is conditional grants. Conditional grants. This was largely the aspects. And then what happened gradually, we are talking about overall fiscal federalism, how it has changed. I mentioned in the recent 2-3 decades, fiscal federalism has improved. Fiscal federalism has improved. That's what is your actually in a way answer. Fiscal federalism has improved. How do you say that? First one. First major change is what? Post 14th Finance Commission, vertical devolution has increased. Post 14th Finance Commission, vertical devolution has increased. Within that specific numbers, if you want, 14th FC 42, 15th and 16th 41. 14th FC 42%, 15th, 16th FC 41%. 14th 42, 15th and 16th 41. Well, that's the first major change. Second major change, Niti Aayog replaced Planning Commission. Niti Aayog replaced Planning Commission. It follows bottom-up approach and has no role in financial resources allocation. Niti Aayog replaced Planning Commission. It follows bottom-up approach. And it has no role in bottom-up approach and it has no role in financial resources allocation. It has no role in the financial resources allocation. Then 3. Third one, GS-2 Council, Article 279A, GS-2 Council with representation, or you can say equitable representation of states. We call 2/3 representation for states. GS-2 Council with equitable representation for states. Bracket 2/3 of the strength. 2/3, 2/3 of the strength. 2/3 of the strength. Fine. The next one, rationalization of centrally sponsored schemes. Rationalization of centrally sponsored schemes with increase in untied grants. Rationalization of centrally sponsored schemes with increase in untied grants. Increase in untied grants. Increase in the untied grants. The next one, Act, FRBM Act. You know that economy, Fiscal Responsibility Budget Management Act, FRBM Act. NK Singh Committee recommendations. FRBM Act, NK Singh Committee recommendations. NK Singh Committee recommendations to promote financial fiscal discipline among states. Of course, both center and states in a way. NK Singh Committee recommendations to promote financial discipline among both center and states. Among both center and states. These are major changes that have happened in the last 2 to 3 decades. Now, then what? Present challenges. What challenges still remain? Present challenges. With respect to fiscal federalism only we are telling. So many other challenges, governor, all of that will not mention here. Present challenges. First one, if you recall, which one kind of economy angle? Cess and surcharges have increased. What is it not? Yeah. Cess and surcharges have increased. It is not part of divisible pool. Means net proceeds of tax, sharing between states. Cess and surcharges have increased. It is not part of divisible pool. If you have doubt in bracket, not shared with states. Not part of divisible pool, that is not shared with states. Not part of divisible pool, that is not shared with the states. Right, that is first major challenge. And then second major challenge. 3% limit. 3% of the GSDP limit. 3% of GSDP limit. The borrowing powers of states. Means states cannot borrow more than 3% of their state GDP. 3% GSDP limit on the borrowing powers of state imposed by center. On the borrowing powers of state imposed by center. Imposed by the center. Fine. The next one. South and western states. South and western states. South and western states are not happy with. South and western states are not happy with horizontal devolution criteria of Finance Commission. South and western states are not happy with the horizontal devolution criteria of Finance Commission. Of course, they have continuously improved the criteria, but still they keep on opposing it. Horizontal devolution criteria of Finance Commission. Bracket famously done. My Tax, My Right campaign of Karnataka. My Tax, My Right campaign of Karnataka. My Tax, My Right campaign of Karnataka. Then GST compensation fund and cess issues. GST compensation fund and cess issues. What does that mean? It is not regularly transferred to the states. It is not regularly transferred to the states. Not regularly transferred to the states. Then within GST, another question what they tell. The fourth should be the voting aspect. That's a different issue, though it is dominated by. Okay, yeah, in a way you can write that. Post GST, different way of writing it. Post GST, states fiscal autonomy Post GST, states' fiscal autonomy has reduced. States' fiscal autonomy has reduced as indirect taxes are merged. States' fiscal autonomy has reduced as indirect taxes are merged. Subsumed. Indirect taxes are merged. That's in a way another criticism. Indirect taxes are merged. Then next one, if you want, states expenditure has increased disproportionately compared to their increase in revenue. States expenditure has increased disproportionately compared to their revenue. Increased disproportionately compared to their revenue. Right. These are the broader aspects. The states cannot borrow outside the country is also a limit if you want. If you want, you can just mention that challenge also. Constitution allows center to borrow both within and outside the country. Constitution allows center to borrow both within and outside the country, but states are not allowed to borrow outside. Actually, they tried long back, but for that constitutional amendment is required. Center is allowed. Constitution allows center to borrow both within and outside the country, but states cannot borrow outside. States cannot borrow outside the country. States cannot borrow outside the country. These are the major issues. Then, way forward. How do you address these fiscal federalism issues? Way forward. Especially fiscal angle only have to talk. Way forward. Under that, cess and surcharge should be part of the net divisible pool. Cess and surcharge should be part of the divisible pool. In bracket, Punchi Commission. Cess and surcharge should be part of the divisible pool. Punchi Commission. Punchi Commission recommended according to Punchi Commission. Punchi Commission. And then save 2. Second one, state should be consulted. State should be consulted while drafting TOR of FC. This is also Punchi Commission. State should be consulted while drafting terms of reference of Finance Commission. TOR of FC. Again Punchi. State should be consulted while drafting TOR of FC. Punchi. Punchi Commission. Right then. Says states should be allowed. States should be allowed to borrow outside the country based on specific criteria. With the states should be allowed to borrow outside the country based on specific criteria and with the inclusion of or with the because this guidance of RBI and with the guidance of RBI. The guidance of RBI. Then you can say what you call it, differences with respect to GST Council. GST Council and GST compensation should be addressed. GST Council and GST compensation should be addressed. GST Council and GST compensation should be addressed. Then vertical devolution can be increased. Vertical devolution can be increased to reduce dependency on center. Vertical devolution can be increased to reduce dependency on the center. Reduce the dependency on center. Fine. So these are largely your fiscal federalism. That's in a way answer for your 2025 question also. But then we'll do that again later. And then bargaining was there. That's not important. These are your federalisms one. In and around most of the questions you can answer it using that. Of course, some specifics will be there. PVQ answer writing part we'll do. I will start that today. We will start that tomorrow. As I told, which one? Federalism, panchayats, municipalities, and then if possible, 5th schedule, 6th schedule. We'll see all of that possible. We'll discuss interstate, interstate, your interstate council related topic. Zonal council is not important, but interstate council one or other way will always be important. So all of that we'll try to discuss it under this broader topic of federalism itself. Fine. Then we'll go back to your another two important topics, which is which one? Legislature, that is parliament, judiciary, all of them will continue after this particular topic. Right. We'll come back tomorrow, same timings, 9 o'clock.